With us today as our visiting scholars in practice are Peggy Brockington and Brian Tyson, here to discuss with you HIPAA, what it is and why do we care. Peggy is a partner at Strickland Brockington Lewis. Her practice focuses on education, employment, and litigation. She's a member of the State Bar of Georgia and the Atlanta Bar Association and the National Association of College and University Attorneys. She received her Bachelor of Science with distinction from the University of Kansas in 1973 and her law degree, magna cum laude, from Georgia State University in 1986. With her is Brian Tyson, who is an associate also at Strickland Brockington Lewis. His practice area focuses on election law and government, along with appellate advocacy. Brian worked for 7 years in the General Assembly, followed by 2 years as a policy aide to Georgia Congresswoman in Washington, D.C. He is a member of the Georgia and California bars and the Atlanta Bar Association. He earned his law degree magna cum laude from the Oak Brook College of Law. I have enjoyed my brief time with both speakers. I think that you'll find them both informative and entertaining, and I welcome them to the podium. So please join me in greeting them.
Briefly. Good afternoon. Brian and I are indeed honored to be here. First off, I do want to say that I'm Peggy and this is Brian, if there was any confusion about that. It is an honor to be with a group of people who do one of the most important areas of law. We don't do juvenile law, and we have the utmost respect for everyone involved in the whole area of juvenile law. I do a lot of education law and used to teach school decades and decades ago, and had a lot of involvement with child welfare agencies through that process because I taught special ed and had a lot of special needs kids, obviously. We aren't experts at juvenile law, though. We do a lot of work with HIPAA and other related privacy statutes and represent generally the institutions who are responding to requests for records and are generally trying to give those records without buying liability under some statute or another. And so we try to give advice that is calculated to get the information that is needed to the scholars, the lawyers, everyone who is working on a particular program or project or needs records immediately, but without exposing the entity that we're working with to liability. Brian is the brains of the outfit. He has done a lot of work on policy development when he was in Washington and when he worked in the state of Georgia. Obviously, HIPAA is a federal statute, and so he's very interested in policy and the interpretation of policy and regulations. And I don't want to refer to him as wonkish, but because he's far, far beyond that. But he knows, the intricacies of the law itself and all of its varied applications. And so he's going to begin the program by talking about HIPAA and kind of walking you through all the basics of it. How many of you have bumped up against HIPAA issues with some difficulty during your practices? So probably 25% of you, maybe. And I'm sure that most people are familiar or have some sense of familiarity with HIPAA. We're not going to talk about all of the repercussions, including what's happening with the Healthcare Act and how it might impact, but we want to walk you through it, help you understand it so that when you come across it, you know the way to apply it and get what you need promptly and efficiently. During this program, please feel free to ask questions anytime. You're not going to be interrupting us. Don't ever hesitate, because I think if you feel a need to get an answer to a question or to get us to clarify something, do it at the moment so that you don't lose your thought and we can clarify something if it needs to be clarified for everyone. Before I let Brian begin, though, I just want to tell you how I got involved with this, working with the Barton Center, and doing this program was several years ago. I had a request from a client who had a healthcare clinic, and it was a university, and they had a request to their clinic from DFACS for records related to a child whose parents were suspected of child abuse, and DFACS had custody of the child and had requested the records, and this clinic wanted to produce the records, but because of the fact that, and DFACS was saying, well, we'll sign off on it and authorize you to give us the records, and this clinic said, well, we aren't sure that that's sufficient because you have custody, we understand that, but we're not sure that that complies with HIPAA, and because of the dangers of walking into a HIPAA violation, they wanted help, and we filed some papers in the court and ended up going to court the next morning, and all we had to do was talk to the judge about it and got a court order, and everybody went on their way. But because of that, there has been a need expressed throughout the legal community for some kind of on-the-ground practical suggestions about how to deal with HIPAA from the courts, from the judges' clerks, from everybody. And so that's why we're here today, and we are open to whatever questions, and if we can answer them, great, but some of them are not answerable. And we're happy to discuss anything, and we don't consider ourselves the experts in the field of juvenile law. But so let us know what your concerns are, and we'll have plenty of time at the end for questions too, as well as during the program. So the other area in which that we're going to touch on just a little bit is, and a very little bit, but insofar as it may be related to HIPAA, is the federal statute called the Family Educational Rights and Privacy Act, FERPA, which also contains very similar but not exactly the same privacy requirements that apply to schools, colleges, universities, anybody who receives federal funding, basically. And so those two kind of touch on each other at various points, and that's how I first got involved in the area of privacy and records and production of records. And so a lot of the things that we've done under HIPAA, we've also done under FERPA. So we'll talk a little bit about that as well. And with that, let me introduce Brian to you and let him get started. Thanks.
All right, let me get our All right, HIPAA. What is it and why do we care about the Health Insurance Portability and Accountability Act of 1996? And more often, why in the world do we have 1996 law impacting us so recently? That's one of the things that confused me initially when I first looked at this question. This law was passed several years ago, but yet it has a dramatic impact on what we're doing today and really has only started having that impact within the last 5 to 7 years. There's the HIPAA Act, after the first privacy rules went into effect in 2003, began to have a lot of myths associated with it. And we all saw the impact of HIPAA, whether that was nurses crossing out names that were on the sign-in sheet at a doctor's office, nurses turning away, closing up medical records if you walk up to a nurse's station at a hospital, people being more guarded about things when they talked about medical issues. But there's a lot of myths that went along with HIPAA. And one of the big myths initially was that HIPAA prevents providers from ever disclosing anything about medical information to anyone but the patient. And that's not true, as we'll look at. HIPAA provides a number of ways that you can get information about healthcare and some limits on how that happens, but it doesn't completely prohibit a provider from providing medical information. It just restricts it a little bit. Another myth about HIPAA is it prevents doctors from exchanging emails with their patients. HIPAA and the HITECH Act more recently have a number of rules about health information technology and the availability of electronic health records, but they don't prevent or prohibit a medical provider from exchanging information with the patient through other means, such as technology with email, things like that. That's not one of the goals of HIPAA. It's just trying to restrict the disclosure. Another interesting myth about HIPAA: medical information can never be legally sold or used for marketing. Actually, lots of medical information can still be legally sold and used for marketing. If, for example, your hospital that you've been a patient at has a new service they want to alert you to, they're allowed to use that medical information to tell you about it because they're using it within their own entity. Similarly, people always thought, well, you've restricted the use of medical information as it relates to health studies and things. As long as it's not identifiable, as we'll talk about in a minute, you can do pretty much whatever you want to with health information. Now, my favorite myth about HIPAA was one that went around among churches, was that you were not allowed to offer prayer requests that shared medical information in your church for fear of violating HIPAA. As we'll talk about a little bit later, that's a myth, but it was an interesting story that went around, so we'll talk about that. All right, so HIPAA. What I want to do is talk a little bit about how HIPAA came to be, and then walk through some of the basic terms that we really need to know to understand how HIPAA actually works. So when the law was originally passed in 1996, it was primarily focused on a need that Congress recognized, that people change jobs a lot. Generationally, there's much more now people moving from job to job to job instead of working for the same place their entire life and having health insurance through that employer. So the idea Congress recognized was, well, people need to have their health care be portable. We need to carry it around from job to job. And so HIPAA primarily was aimed at portability in the health insurance market. That was the primary goal behind it. But interestingly enough, Congress included a provision triggering something else. Now, basically what the law said was, in 1996, Congress said, well, we're giving ourselves as Congress 3 years to pass a rule about medical privacy. And if we don't pass a law within 3 years, then there's going to be this trigger happen, and the Department of Health and Human Services will then be empowered to make a regulation protecting privacy of health information. Now, unsurprisingly, Congress did not act within those 3 years, and the Department of Health and Human Services moved forward in 1999 to establish what became known as the HIPAA Privacy Rule. And that's the system we work under today. After a long period of comment, a lot of work on it, the rule first went into effect in 2001, and then the other implementation date was 2003, which is when most providers had to be in good faith compliance with the rule. So law passed in 96, the trigger happened in 99, took a couple years to get it put together, a couple more years to get everybody on the same page. So 2003 is really when the HIPAA privacy rule began to affect dramatically the way health records were treated. Now, the key definitions we need to know about HIPAA is this first one I've listed here, protected health information. And this is the buzzword that's used in the regulation to say, here's what we're going to protect as it relates to health privacy and medical privacy. Now, what the idea behind the HIPAA privacy rule said was the individual owns his or her own health information. So I have the car up here to say, basically, it's like you own your own car. You get to choose what to do with this car. You get to choose what to do with your protected health information. So if you want to, you can take that protected health information, you can broadcast it to the world, you can share it on a blog, you can send it out to everybody you know if you want to. That's one option. You can try to keep it as restricted as possible and not share it with people. That's your choice. You're the owner of this protected health information. So similarly, with your car, you get to decide, hopefully, who drives it and who doesn't. You get to make that decision. You can decide to loan it out to anybody who comes along. You can decide to only let you and your spouse drive it or not let your kids drive it at all, depending on what kind of car it is. But just like with your car, there's obviously certain exceptions. If your child isn't old enough to drive, you have to drive for them. Similarly with HIPAA, if you're protected health information of a minor, the parent or the legal guardian has the responsibility to basically shepherd that information while the child is unable to do that themselves. So it's critical to understand that just because something contains medical information, however, that doesn't automatically make it protected health information. And the key word when you're dealing with protected health information is that it has to be identifiable. So you have to be able to say, this health information relates to this person. It's not just a matter of saying it's general health information about someone that you know. So for purposes of HIPAA, we're only concerned about whether the statement, Brian Tyson has had chicken pox. Okay, this is a statement about me, about my medical history. It's identifiable to me. If I say that one of the two speakers before you has had chickenpox, it's maybe not identifiable because you're not sure necessarily who it is.
Sort of like slander, you know?
Exactly. You have to be able to identify.
Have to be able to identify the person.
That's right. But if I say the male speaker before you has had chickenpox, even though I'm not saying my name, that's one of two people, you know exactly who that is. So according to the HIPAA privacy rule, that is identifiable, therefore it's protected health information. So the key thing to remember when you're dealing with protected health information, does it identify the person that we're talking about? That's what makes it the key there.
Before you move on to the next category, protected health information, is it protected health information that I went to the hospital?
No. Just
Or that I was a
hospital.
patient
Right.
of a particular doctor? Is that protected?
No, what we're looking for with protected health information is specific information about your treatment or about medical conditions that you have.
Okay.
So it's almost the analogy, Peggy will talk about FERPA in a little while, but the analogy of directory information. It's not necessarily protected student information that you attend a particular school. It is protected what's happened to you in your academic record at that school. So the same type of thing applies with HIPAA. Now, a lot of providers have been very careful to guard the fact that patients are there. So, for example, you'll see if you sign in at a doctor's office, a lot of times they'll go in and black out the names after they've checked somebody in, just to kind of have an additional level of protection about the information that's there, especially if it's a specialist, because you're probably there for a particular reason. And that could be protected health information at that point. All right, the second concept that's important as we relate to HIPAA is the concept of covered entities. Because just because someone's protected health information is disclosed, that doesn't automatically mean there's liability under the HIPAA privacy rule. The covered entities have the highest burden as it relates to disclosure of protected health information. So a covered entity is one of three types of individuals, or three types of groups. It's a health insurance plan or a co-op, it's a healthcare provider like a doctor or hospital, and it's a healthcare clearinghouse, a place that regularly holds medical information or assists doctors, a billing service, things like that, that regularly traffic in protected health information. Basically, what the privacy rule aims for a covered entity is people who are actually providing the health care, people who are paying for the health care, and people who regularly traffic in healthcare information. They're covered entities, and they have the highest duties under HIPAA to avoid disclosure of protected health information. So here you have your doctor's charts. They have key medical information. It's the doctor has that in his possession or in her possession in their office, and their staff has access to it. All that their office staff are considered providers for purposes of that. Similarly, insurance information about pre-existing conditions, insurance information about specific treatments that were done for an individual. That also is protected health information being handled by a covered entity because they know something very specific about your medical background and your medical history. Now, one weird wrinkle about this is if it's a close question, if somebody is a covered entity or not. So, for example, you have a university that has a medical school attached to it and has a clinic attached to that.
A hypothetical one.
Hypothetical, that's
not
right.
one nearby.
So you take the clinic obviously has a lot of protected health information. The med school might or might not have protected health information. The university probably doesn't. So what is that? Is it a covered entity or is it not? And what HIPAA says is the entity gets to self-identify basically. We're going to consider ourselves covered for purposes of this, or we're not. Consider ourselves a weird hybrid thing where they can say, well, we're walling off the medical portion of ourselves and the rest of ourselves is not covered. Now the key thing for...
Do they get to make the designation of whether they're hybrid or whether they're covered, or how does that work?
Yes, they get to make the designation. If they have components that are medical and non-medical, they get to make the designation. Basically, they can be a hybrid entity, which says we're separating our clinic role from our university role, for example, and the clinic is going to be covered for purposes of HIPAA, but the university will not be. That'd be a hybrid setup, or they could say, well, we're just going to have everything be covered and have HIPAA apply to everything. We're just going to kind of do the whole thing. So they have that option. Now, the key thing about this, the concept of covered entities, there's a listing here for business associates. And recently, Congress has expanded the liability of business associates. A business associate is someone who is not a provider of medical information. They're not someone who regularly deals in the healthcare world, but they get access to healthcare information because they are working with a provider or with a covered entity. So as an example, the cleaning crew that comes through at night and cleans the doctor's office, they have access to the doctor's charts depending on the setup of the office, and they are a business associate. They're not dealing regularly with healthcare information, but they could get access to it very easily. Or the company that has that is the server information for a doctor. They store the electronic health records in an off-site server. That's a business associate. They have these private medical healthcare records in their possession, but they're not really providing that service. They're just providing a server which happens to contain the data on it. Or for us, we represent clinics, those types of medical providers. They sometimes share with us as their lawyers protected health information. We're business associates. We've obtained that information, and there's liability in a large way for a lot of business associates because they have these types of protected health information.
And if you are a business associate of a covered entity, you must execute an agreement, a business associate agreement, whereby you acknowledge your responsibilities under HIPAA and designate exactly how you're going to deal with it and tell them how you're going to keep this private, et cetera. And that the requirements for that business associate agreement have been really tightened up a little bit under the HITECH Act, which Brian will talk about. So if you work with or are part of a covered entity, you need to make sure that the folks who do work that in which any kind of work in which they would have access, that they execute business associate agreements.
Absolutely. So your four key definitions you have to remember. What is HIPAA? Basically, that's our first one. PHI is protected health information. That's our key thing we're trying to protect. A covered entity is your providers, your insurers, that's your covered entities. They have the highest duty to protect information, and business associates are the ones who have to come into contact with PHI, but don't necessarily have to have an affirmative duty. They have a duty to protect, but they don't deal with it regularly. So that's our first kind of categories of people. Now, when we talk about disclosures is what the HIPAA privacy rule is focused on. It says we have these covered entities, they've got this protected health information. They can only disclose it in very limited circumstances, and the limited circumstances are what y'all are focused on primarily as it relates to child welfare types of cases. You need access to this PHI, but you've got to get to it somehow. Now, a disclosure of protected health information is anything that reveals protected health information to someone who does not have the right to access that information or to know that information. So it can be as simple as a doctor walking up to me and saying, hey, I just performed cosmetic surgery on your neighbor, Joe Smith. He's now disclosed to me medical information about Joe Smith. He's a provider, he's a covered entity, and I didn't really have any reason to know that. He just shared it with me out of nowhere. It's a disclosure of PHI. Or it could be as complicated, that's kind of the simple scenario, it could be as complicated as a medical provider who has some massive database that accidentally gets exposed on the internet for several hours, and people can access health records, hear about these types of medical disclosures in a kind of a credit card context. People get credit card numbers posted, all those types of things. Could be a very complex disclosure of protected health information. But either one, they're both the same thing in that protected health information is being made known to people who shouldn't have access to it.
Can I follow up with one thing? The HIPAA limits disclosures, and it doesn't require disclosures. The purpose of the statute is not to say that covered entities must produce records. That would depend on other obligations under state law, such as a medical doctor's obligation to produce records to the patient because they belong to the patient. So that seems like a kind of a silly distinction, but it is an important distinction because a lot of times folks think that if they get a HIPAA authorization that they must produce whatever it is that is being sought. And it is not a mandatory statute as far as that you have to give up these records. It just places limits. So.
All right, so as a general rule, disclosure of PHI by a non-covered entity results in no liability under HIPAA. So this is my church example from earlier. You share Aunt Jackie has a thyroid problem, please pray for her healing. We know Aunt Jackie, that's identifiable, it's protected health information about her, it's a specific medical condition she has, but the church in almost every case is going to be a non-covered entity for purposes of HIPAA. Church generally isn't providing the medical care. It's not the doctor. Now, if it was the doctor who was saying that, who was providing that care, that could be a problem. But if it's just a random family member, the church isn't providing medical care, that's a non-covered entity. There's no liability for disclosure of that health information.
What about an employer? One of the categories you said was for who might be a covered entity was someone who pays for health care. If an employer provides insurance or is self-insured, for example, is that employer covered under HIPAA as a covered entity?
If the employer is paying for as a health insurer is paying for the care, then any information they have as a result of that job, basically if they had medical records that they were obtaining as an insurer for that, would make them covered. A disclosure of that would be a violation of HIPAA by a covered entity. But the key is non-covered entities, no liability. Covered entities, humongous major liability for these groups that are covered. Now, one other piece of the puzzle, actually there's two other pieces of the puzzle, the HITECH Act I've mentioned a couple of times. Congress upped the penalties for the violations of HIPAA as it relates to especially electronic health records in 2009. And now the liability for disclosure of PHI for the civil penalties ranges you up to, depending on the situation, up to $1.5 million. The criminal penalties, you generally have $100,000 to $250,000 of fines, 5 to 10 years in prison, depending on how knowing the particular violation was. So the penalties are dramatically increased, and Congress added business associates who make disclosures have just as much liability as a covered entity who makes a disclosure. So Congress really was focusing in on this problem of disclosures by people and making sure there's some pretty serious teeth to keep that from happening. Now, the one other piece of the puzzle is an additional federal law, which is relatively recent, the Genetic Information Non-Discrimination Act, which is known as GINA. And part of that law, basically Congress told HHS, we want you to go back and add some more information to the HIPAA privacy rule to protect genetic information so that health insurers can't use that in coverage decisions primarily. Those changes have not been made. There probably will be some impact on that in the future. We don't know what that'll be yet, but that's kind of out there along the way. That's a little bit farther out.
And GINA also has repercussions for employers, just as a side note. Yeah. It doesn't just apply to covered entities under HIPAA. It would apply to employers generally. So a whole new scary thing to be worried about.
That's right. All kinds of
question
things.
Back there.
Oh, question. Let the microphone get to you.
I have a question about not the covered entity, because I think it's clear that the Department of Human Services and DFACS is covered under it. What I'm coming up against is a situation where the department has done a family assessment. In that family assessment, Uncle John told the department, I suffered depression as a child. And then we're asking for the family assessment either as the child's attorney or the parent attorney, because it includes good information about possible family resources, etc. And we're being told, no, we can't release it because it has protected health information. And I always wondered about, is that in fact protected if Uncle John is telling them and it's not in fact Uncle John's medical records or anything to that nature?
And that would be considered protected health information because it's identifiable to Uncle John, and a covered entity basically is in possession of it. Okay. So they're going to consider it that way. And we'll talk about in a little bit the ways you can get at that information, because if you don't have Uncle John's approval to release that information to you, there are some other ways you can get the information, primarily through a subpoena, a court order, but we'll talk about that. Okay. But that's the primary scenario that a lot of people are running into, from what we understand, is the protected health information of someone else, basically. And it's not the child necessarily whose protected health information you need. A lot of times you have access to that information. It's the family members in that family assessment and others where that is. So yes, that is protected health information. And yes, there are ways to get to that.
Okay, and what about the situation where the protected health information may be about the child itself, whereas the department has legal custody of the child, but the parent still keeps their legal residual rights to the child? Is that circumstance, does the parent still have, first of all, I don't know who they'd get a release from because they're the actual parent. but how you would obtain that information and whether it's covered or not, because you're the ultimate custodian of the child.
Right, and that's actually the scenario Peggy dealt with originally in the case she was referring to earlier, where the parents were trying to intervene in the situation. DFACS was trying to get the medical information. It was kind of, everybody was trying to figure out who actually has responsibility to authorize it. And the kind of easy answer to that is if you can get the court order, you're covered as to everything. So we'll talk a little bit about that as far as how we get access to that as we move along here. So.
Okay, thank you.
Now, what I want to do next, we want to talk about, Peggy's going to come talk about the interaction with other federal laws and other state laws. So HIPAA is one area you have to deal with as it relates to confidentiality, but there are other laws that can govern records. So just because, for example, something can be disclosed pursuant to HIPAA, that doesn't necessarily mean it can also be disclosed pursuant to state law or pursuant to other federal issues. And so Peggy's going to first talk about student records and FERPA and how those can sometimes be covered by HIPAA and sometimes not.
Right. And I don't know how many of you have bumped up against, in dealing with child-related cases, if you have bumped up against FERPA. I'm not sure, but FERPA is the federal act that protects education records of students, and it has a whole lot of other provisions, but it makes those records private other than what is deemed directory information, and directory information is identified by the school or the school system or whatever as what is directory information. The student was a student at this institution from this year to this year and got a degree on X date. That's generally going to be directory information that is subject to public knowledge, unless the student or the student's parents, in the case of a minor, have said, I don't want any of that released. It can be as much as he plays football or got a scholarship or any names and addresses. But FERPA does protect what is in a student's education records. It permits parents of students to have access, of minor children, to have access to those records. And so, it may be that if you try to get school records, you may bump up against FERPA, and there are ways to get records under FERPA that are very similar to the way that you can deal with the restrictions under HIPAA for getting records. But there are some times when those two things they overlap. For example, if you have a school that has a clinic within its school, and a child has been seen in that clinic and perhaps reported sexual abuse, or there's going to be, those records would come under HIPAA. The records that relate to if the student is being treated in a clinic, whether it's a psychiatric, psychological clinic, counselor, that would come under HIPAA. It could also come under FERPA if it's a counselor that's at the school that isn't necessarily a medical provider, but is providing confidential information. And so I see this, it can get even more complicated if you're in a situation, say, on a college campus where you have a rape that occurs on the campus and the campus police investigate it. Their records are not covered by HIPAA or FERPA. So whatever their investigation involves is public. FERPA would govern if there was a disciplinary action against that student or the perpetrator. FERPA would guard those records, and it would also guard the records of the victim. But then if that institution also had a clinic on its campus, those clinic records would be protected under HIPAA. And so there is an interplay among those, or a potential interplay that you just should be aware of, and particularly if you're requesting school records as part of a package of information on a child. Yes, ma'am. Question in the back.
Okay, so under FERPA, my daughter is 17 and she attends college, and I wanted access to her academic progress. And They initially would not give it to me, but she's still 17. They wanted her to sign something, a release, to give me that information, but I spoke to who I spoke to, and I told them she's a minor and I should have access to that, and they released it to me. Who was right in that case?
Well, if a child is a minor, the parents have the right to all of their school records. And so it's going to depend on what is a minor under state law. And so the final advice that you got was correct. There is an exception for when a child passes the age of minority. The child is the only person who has the right to those records unless the child is a dependent of the parent and under IRS rules qualifies as a dependent. And so there may be issues about how much support the parent is providing. And in the college scenario, we see this a lot with parents who they want their kids' grades. And they want to call the professor and talk to them about why their child got an undeserved D, etc. And they bump up against this all the time. And it really comes down to age of majority. Once they pass into majority, the student has the right. Now, a lot of institutions will ask their students up front at the beginning, you know, if their parents can have access to this information. And they usually give out those forms when the parents come to the open house with the child, or you know, when they deliver them to campus and they're signing a whole lot of other things. That may be when it happens. But
and just to clarify, for purposes of HIPAA, the dependent rules have nothing to do with HIPAA disclosure.
Right.
So that's a FERPA thing, has nothing to do with when you can or who can access medical records and PHI for HIPAA purposes.
So if you can go back to children who are still under the age of
Yes.
not majority. So if we're talking about discipline records and we're talking about IEPs for children who have special education, can you talk about because we run up against if it is DFACS or if it is the district attorney or if it's the intake officer or if it's the child or guardian ad litem's attorney getting certain records from the school. So what's the interplay between FERPA and special education and discipline in our...
Well, FERPA covers
Right.
those records. That would include IDEA records. It would include disciplinary records. It includes academic records. It includes all testing that is done on the child, test reports that are included in a child's records. So it's going to include all of that. And so you would have to get, in order to get those records, if you would you be representing who? Okay. Well, they would need either an authorization from the parent, or they would need to have a court order or a validly issued subpoena, which would be considered if it's under state law, a subpoena that's issued out of a Georgia court, or in federal court, a subpoena out of any federal court would be considered a valid subpoena. Well, yes, there is a restriction if you are requesting records under FERPA, and I believe this is the case under HIPAA as well. Under FERPA, any request for records must be specific. It must identify what specific records are being requested, to whom the records are to be produced, the person, individual, etc. And number 3, identify the purpose for which the records are being requested. If the letter or whatever with an authorization includes all of that information, then those records can be produced. Now, under FERPA, unlike HIPAA, FERPA requires a school with minor children to produce the records of that minor child to the parents, or to let them come in and review the records, see the records. It does include a mandatory, and with an adult student, the same thing holds true. A student has the right to go in and see their records under limited, you know, it has to be reasonable, the request has to be properly limited, and it needs to be a reasonable amount of time. And if somebody wants their records sent, you know, 200 miles away, the institution can make some limitations on how that's done, so that it's not overly burdensome to the institution. But you would want to identify IDEA records, you would want to see that they were requested in that subpoena, or issue a court order. And when an institution receives a record, I'm sorry, a subpoena or a court order, once they determine that it's proper, they have to give the student, if it's a minor child, the student's parents notice of their intent to produce the records, and in sufficient time. They have to make a reasonable effort to notify the parent, so that then the parent can go to court to object if it's a subpoena issued out of a court, so that they have an opportunity to object to the production of it. If it's, for example, if there are two divorced parents, one parent wants them, the other doesn't want them to have them.
Let me clarify. I'm sorry.
I was going to say, but in our situation, it's most likely going to be a guardian ad litem appointed to act on behalf of the child, so the orders are going to set it forth. So if that person goes over to the school with that order, do they have the 5 days notice, or since they are acting as the child's guardian ad litem, can they just look at the documents?
Well, they should be able to look at the documents. It depends on how the order is worded. You want to make sure that the order specifies the documents that they are going to be provided access to, and not just an extremely broad, and I think this is the case under HIPAA as well. It has to be properly limited. But so when you draft an order, and we will provide you with some sample orders that specifically designate, and I'm not sure that they're FERPA necessarily. These are really HIPAA, but it's a similar theme under FERPA.
And one other important issue, I think, with IEPs, particularly in IDEA, is when you're dealing with the special education context, there may be in an IEP a very specific medical information about a child contained in that IEP. HIPAA says if that's the case, if protected health information is contained in an education record, look to FERPA, don't look to HIPAA. So when you're dealing with IEPs, IDEA, those types of things, FERPA is the governing, controlling privacy law, not HIPAA. So even though you've got protected health information, HIPAA says refer to FERPA if it's in an education record. So just to clarify that.
Would you address properly issued subpoena? Signed by a clerk?
Let Peggy answer that.
Under
Yeah.
state law, it should have a judge. I would interpret it, and this is just me. I'm not. I think it's every subpoena we look at very carefully in deciding whether under FERPA it complies and is validly. It has to be issued out of a court that has jurisdiction over the entity from which the records are being sought, and it has to be signed by, I believe, an order should be signed by the judge. I would interpret it that way. I have not seen a case that specifically says that if it's signed by a clerk, it's not valid. It really depends on state law under Georgia law, and I've never had that occasion come up, but I get a lot of subpoenas for records on children or students that come from out of state and might be issued out of a court in, say, Florida. And if it's issued out of a Florida court, it's not valid in Georgia, and they would have to come in and get a subpoena issued out of a Georgia court.
Then would you address a standing court order for protected health insurance out for the protected
Information? Yeah. You want to talk about the standing court
Yeah,
order?
we're going to get to a standing court order as a way to deal with getting protected health information, so we'll come to that in just a little bit, and I have an example for you. Just as far as one other area of the kind of this interplay of HIPAA with other laws, Georgia obviously in OCGA 49540 and following has a number of rules related to the confidentiality of child maltreatment records particularly. And in child abuse cases, child welfare type cases, those are going to be issues you'll deal with. And just because you have an authorization under HIPAA, you have to make sure you also have a separate, or you've met the right requirements under state law. So just because you have one doesn't mean you have the other, and you've got to check and make sure both of those remain the case. And just the reverse is true. Just because someone has access to the protected health information under Georgia law doesn't necessarily mean they have access under HIPAA as well. So be aware of the interplay there.
My question is in regard to, I know you were talking about the counselors at a school. along with FERPA and along with HIPAA, what about if you've got up underneath the mandated reporter rules, that you've got somebody out of that school by the mandated reporter rules making that report of some type of abuse, sexual abuse, whatever it may be, from the child directly over to the department for them to investigate?
I think the key there goes to who is making the report. If it's the school nurse in the clinic, then you've got a HIPAA issue because the school is providing it. It's a covered entity there. If it's the counselor providing it, then you've got a FERPA
Or the teacher.
direction. Or the teacher, yeah, same way. As far as you need to know from the department who's actually made the report, is that what you're looking for? Okay. Okay.
Well, you have to follow the provisions
the
of,
same
I mean,
provisions,
HIPAA
yeah.
has certain exceptions for situations where there is imminent harm
Of some
or
sort,
abuse.
yeah.
And that's one of the exceptions to the requirement that you have an authorization or a subpoena or a court order. There is a specific exception under HIPAA, and Brian's going to talk about that, to get you around if there is a situation like I think you're describing.
All right, so what we want to do now is move, this has kind of been our theoretical policy discussion. We want to move into kind of the nuts and bolts of how in the world do you get access to this? And in the child welfare context specifically, I know y'all run up against this all the time. As far as needing, as an example earlier, you need Uncle John's health information from the family assessment, and you can't get access to it because you have access to the child's protected health information, but not the family's. You may need to know if another caregiver has been abusing drugs or has a mental condition. A lot of times the child's protected health information is the easiest information to access, and it's the family that becomes the challenge. So what we want to do is just kind of cover briefly, the juvenile court is not a health plan, it's not a health provider. The juvenile court is not a covered entity, so just kind of clear that out. The child welfare offices, a lot of different people who deal with this are not covered entities by and large. Yes?
There are.
Excuse me?
What about the juvenile courts who have behavioral health screeners that are housed in the court that do assessments?
Then I think you're transforming yourself, that portion at least, into a covered entity because you're providing a medical service at that point. So yes, that's correct. Generally, the judge is not going to be a covered entity, but if you have a thing where you're doing provision of services like that, that's going to apply and the disclosure rules will apply. Now, as we mentioned earlier, the Department of Human Resources considers itself a covered entity because it does a huge amount of provision of services. It pays for a lot of services. DFACS is very, very careful about what it discloses, obviously, because it has a lot of liability on the line if it makes an improper disclosure as a covered entity of protected health information. That's a very dangerous ground for it to be walking into. So for that reason, DFACS is obviously very nervous about disclosing protected health information. Other providers that are dealing with that are nervous about it. And so we want to talk about how do we get to this information. And Peggy's going to first talk about some of the ways we can do that.
Okay. Well, there is a may disclose provision under HIPAA that generally means that a covered entity may disclose the information if the information is about a victim of abuse or neglect or domestic violence, and it can disclose it as required, as provided under law, which would be under Georgia law, under the specific statute for information about abusive situations of child abuse or suspected child abuse in which there is imminent harm. There's a concern of imminent harm. And so, if necessary to prevent this harm, there is a may disclose provision in HIPAA that permits you to disclose that information. If you're talking about FERPA, FERPA also has a similar, that certain investigative bodies, can get information. The police, various entities are able to get in. There are a number of exceptions for the types of investigative agencies that can get in, and they can get records and come on campus if need be under the appropriate circumstances. I think the key is going to be whether the party seeking those records had a reasonable belief that there was imminent harm and that the situation was immediately serious enough to need access to the records right away to prevent that harm. So if that is the situation, though, at some point that the individual whose records are being sought, they need to know that information has been disclosed, and the entity providing that information is going to need to disclose it unless there is a belief on the part of the party who seeks the information that it would impair and or place a child, for example, at further risk if the parent was notified they were getting that particular information. So that is kind of it sounds very broad, and I'm sure that you all come across this a lot, this situation. So you want to make sure that you do have a reasonable belief. The party getting that information has a reasonable belief that it is harmful, and if they don't want to disclose to the party whose records they're getting that disclosure has been made, you want to make sure that they know or have reasonable belief that it would harm the child or the victim of the abuse if that was disclosed.
And again, that disclosure still only relates to the victim of the abuse, not the family members, not the whole other situation. So again, you're still only getting the child's records under that particular HIPAA exception.
The second way is with a court order, and that can be a court order of a superior court, a state court, a juvenile court, and as you raised, does it need to be signed by the judge? I haven't seen any cases one way or the other, but I think the better practice is to see that court order is signed by a judge, so that it's clear that there's no question about it, or it bears a signature, or it's signed by the clerk on behalf of a judge.
I think he
yes.
meant subpoena. I think he meant.
Okay, you're talking about a subpoena.
Right.
Okay. The next option would be a subpoena, and under the federal rules, the judge doesn't need to sign a subpoena. Under the state rules, I think that the clerk signs a subpoena. So that's not going to require a judge's signature if you're talking about a subpoena necessarily. I don't believe that's the case.
Right. But in order to use a subpoena as a way to get protected health information, you have to meet the other two requirements that the statute has. A court order is kind of wide open. If you get an order signed by the court, the covered entity can give any health information they need to give as a result that is identified in that order. It's pretty much wide open. With a subpoena, I think because it's not signed specifically by a judge, there's the additional protections that exist in the law to make sure that that's met. So,
And I think as a practice, because of that, some attorneys will seek that their subpoena be signed by the judge to elevate it to the next level, and I think that's...
Well, and a subpoena has additional protections that are required. The party seeking the records, if they're seeking them with a subpoena, they have to demonstrate that they've made a reasonable effort to notify the party whose records they're seeking before the provider is really safe in producing those records. And that they also have to demonstrate, and so they have to demonstrate that they've made some effort to get a qualified protective order to govern to whom the records are being produced and what the purpose is and the limited uses that can be made of those records. So generally, you're going to have a notice provision, and so it may be more difficult to get a court order or more time consuming, but also it's probably it may be a little more protection for the provider, but it may kind of hamstring the folks seeking the records and make it more difficult for them to get the records. You want to talk about minimum amount? Go ahead.
Sure. Yeah, I was going to say one other issue along that line is the provider. Remember, a provider could always just provide medical records to anyone who asked them with no authorization at all. The risk they're running is if they do that without proper authorization, they're going to be subject to very severe liability. So theoretically, what we're really looking for is protection for the provider, which in most cases is going to be defects with the information they have. So the court order gives you kind of the wide open way to get to the protected health information from the provider. The subpoena gives you a more limited way to get there. You can still get there, but you have to jump through the extra hoops of notifying the individual, dealing with getting a qualified protective order in place prior to that release. Now, even after you have both of those things in place, though, HIPAA requires that the provider can only release the minimum necessary information to meet the requirements of the order. So however the order is worded, however things are written, it's got to be kind of a laser shot of what information is being provided. So if your request is limited to mental health issues, disclosing other protected health information about cancer treatment is not going to be part of that. And so the minimum necessary disclosure says the provider can't give you that other information because you've only asked for this one type. So realize that whenever you're dealing with a covered entity, they're going to be trying to release the minimum necessary information. So you need to be very specific. If you have a family assessment like that and you know it contains specific information about this relative with this condition, you need to ask for that specifically, but also try to get a little bit more room to give the provider some room to give you some additional records. We have a question over here.
I realize that in the schools there are mandated reporters all over. But what happens in the case of a teen who's threatening suicide, but the information is withheld from care providers or people spending a great deal of time with that teenager? How do you balance the necessity for that person to know, to be aware that they're threatening suicide and they found out through another source?
Are you talking about that whether they would could disclose that, someone could disclose that information?
Yeah, could DFACS or whoever is aware of it, can they disclose it, let's say to the home or the agency taking care of the child, that that child is threatening, I mean, like a very current, made the statement, the teacher or someone reported it. How do you balance sharing that information with people that have direct contact and responsibility for a child?
Well, if it's under FERPA, there are exceptions, and I think that the U.S. Department of Ed has made it clear that if it is to protect the safety of a child or a student, that is the most important thing. And so it can be disclosed as necessary to protect that child. Now, under HIPAA, I'm not sure that
To a provider, yeah.
Yeah, I don't know that that HIPAA would apply to that circumstance if it was, well, I think DFACS would be protected if it disclosed that information under the exception to if there was imminent harm to the child. I would think that if I were in the position of of DFACS or an entity who had that information, I would much rather violate HIPAA in order to save the child's life than I would be to try to
Worrying about HIPAA
make a very restrictive
right.
interpretation. And I think with a lot of the school shooting cases, for example, that has come out, and U.S. Department of Ed has been very clear that, look, don't put an overly restrictive interpretation on FERPA so that you aren't letting people know that this person needs help or is at risk of imminent harm.
All right, when you're talking back as to who's the agency who is the protected person to disclose, the questions that the people over there asked earlier about if you're in a CCFA or say in a home evaluation and Uncle Joe discloses he has diabetes, those are reports that are prepared on behalf of DFACS. They contract with that provider to provide those reports for them. So if you want the release, who's the person that releases it? Do you go to the person who prepared the report for them, or is DFACS the owner of that protected health information because it's a contracted report on behalf of the agency that they've paid out to have done so that their workers don't have to do it?
Yeah, the answer would be you can really go to either one, but it's going to be easier to go to DFACS. Along the lines of the minimum necessary disclosures, if the court order says this is what you disclose, so if the court order says you disclose the entire comprehensive family assessment, for example, and all the protected health information that's in it, the covered entity, in this case DFACS, is able to rely on the courts determining what's the minimum necessary and say, well, the court told me the minimum necessary disclosure is the entire assessment. And so I'm going to disclose the entire assessment and there's no liability. You could go piecemeal to different providers if you wanted to, but it's easier just to go to the one shot, go to DFACS, get that all said and done, get the order to get that taken care of. Now, what we want to do next is really talk about how do we make this work as far as getting down to the specifics of getting this information. And the first way, as far as getting it, is primarily from DFACS. You're dealing with a situation where you need information from DFACS about the home environment primarily, not so much about the child, but about the home environment. And the first way to do that is with a court order. So do you want to talk about that, Peggy, or shall I?
Go ahead.
Okay, great. All right, we talked about the direct order. Now we have, I believe everybody has the handouts in your packet here. We have a couple of example documents for you behind the slides that we just want to walk through with you. So as the first example of a document here, we have just an example order in the juvenile court that is in response to the subpoena. This is actually the order that was resulted from Peggy's case several years ago. And there was the subpoena that was served. There was a dispute over who was going to be able to get access to these records. And this is the court order saying, here's the order saying you are to disclose this information. And once you have a court order, you're able to walk through all the gates of HIPAA kind of open before you. The court gets to determine exactly what you get access to, everything like that. It's all before you. You're right there. Now, similarly, if you have, this one obviously refers to a subpoena. If you had a subpoena, you had to notify the guardian. You have to go through the other steps of getting the qualified protective order. But if you just get an order from the court saying, hey, here's how you do it, here's what you do, you're in great shape. That's the easiest way. Now, there's several other orders behind that. As an example from Floyd County, an order to disclose. And this is, again, pursuant to a subpoena, making the necessary findings to say this is what needs to happen. And several other orders along that line behind that. What I want you to turn to next is in the juvenile courts of the Middle District of Georgia. There's an additional document here that was a standing order. Now, this is not necessarily a DFACS-related order, but the Middle District did this soon after HIPAA was passed, related to records in the Department of Juvenile Justice. And basically, they made this standing order the qualified protective order that you could always relate back to when you needed records that were protected by HIPAA. So the second prong of your subpoena issue is having a qualified protective order in place. If you have a standing order from your court that can create the qualified protective order you're looking for, that helps you check off one of those boxes to get access to those records. So this is just an example from a different kind of approach, but in the same idea of accessing protected health information pursuant to a standing court order. And then all you have to do is make the necessary notifications and go forward with the subpoena after that. So that's kind of a more global fix, hopefully, that you could have a standing order in place to help you relate to that. But that could be one way that you could address an issue with the juvenile courts that you work with. Now, obviously, another way to get access to protected health information is to have the consent of the individual who is the legal representative. And then as we talked about, the problem where that gets into a challenge is when DFACS has custody of the child, the parents are trying to get the children back, who is the legal guardian, who is able to consent to the release, who has access to the records, all those types of questions. And in those situations, our thought is you basically try to get the court order just because that gives you the cleanest shot of making sure everything is covered as far as getting access to those records. The providers will be most likely to give you what you need if that's the situation you're in, of actually having that court order in place. Now, the DFACS does have in their training manual about HIPAA compliance, they're going to allow the release of protected health information to a court. And they basically say, well, if we're the guardian, we're going to control the release of the protected health information about the child. But again, they can't control the release of the protected health information about the family member. So it all comes back to, you got to get back to a subpoena or a court order again to get access to the non-children related records. And the last area, guardian ad litem, is someone who's, they've been appointed, they have access to the protected health information of the child because they stand in the place of the parent. So they can always consent on behalf of the child and view the protected health information of the child. But if they need protected health information of a family member, they also have to go beyond and get some additional help to do that because it's not enough. It's not enough just as you're the child, you're the parent of the child, can't access the PHI of your uncles and aunts and others who are involved in the family. Same thing with a guardian ad litem. They get access to the children's records, but they don't get access to the other family members' records. And again, if you're going to deal directly with a healthcare provider, the subpoena is obviously probably the quickest and easiest way if you have a standing order in place. Otherwise, getting a court order is going to be a very good approach. But again, it's the same thing when dealing with DFACS, dealing with an individual healthcare provider. They're going to be looking for the same types of things and saying, where's your authorization? Where is what you need to be able to have? We have some questions? Yes.
I just need some I need some clarification on a couple things. First of all, you are saying that when children are in DFACS custody, DFACS is the one that determines whether or not health and mental health information related to the child is going to be released. Is that correct?
Not in all cases. I guess, I'm sorry, I should have clarified that a little better. It's not in all cases. When DFACS is the legal guardian of the child, they have that determination. And we were reviewing some of the statutes ahead of time. You know, when DFACS has custody of a child, they have access to consent to some medical treatment. And the way HIPAA looks at it is, well, if you have ability to consent to medical treatment, then you're standing in the place of the parent and you can consent for this.
Although the statute says that they have the right, when they have custody, to ordinary medical treatment. So then the question becomes, what's ordinary medical treatment? So I didn't mean to interrupt. Go ahead.
So I guess what I want to say is, we don't know necessarily as far as the exact legal guardianship, but if DFACS is the legal guardian, they have the ability to control the protected health information.
Okay, and how that comes up is that when, if deprivation is found, then DFACS is granted custody of the child. So are you confusing custody and guardianship? I mean, so I needed to understand that. The second question I have is, in cases where the child has a lawyer, say for instance that the child has some mental health issues, and DFACS, of course, as part of their routine intake, you know, has the child undergo a psychiatric or psychological assessment. You know, now the children, for example, in Fulton County, have their own lawyers, and can the child object through their lawyer to DFACS releasing information that the child does not want to be released? Because we have there 3 parties in the courtroom. We've got DFACS, we've got the child, and we've got the parent. But now the children have their own lawyers. And so as a children's lawyer, can I say, well, I don't want you to release his psychological information?
I think if you think that's in the best interest of the child, you definitely can say that. But the key is you've got a judge to decide it. So you can make that objection, and all 3 parties can make their objections. The judge is going to listen to those objections and make a decision which obviously somebody's not going to be happy with. But at the very least, what we're talking about is HIPAA violations. No one is going to be in violation of HIPAA if there is a judicial order saying, I've considered these arguments and here's what I think needs to happen, and there's a limited order that identifies what can be given and to whom and for what purpose.
And that goes to clarification of the third question that I had, because a lot of times when we're in court, I'm a child attorney, and what we see is the SAG saying, we don't have to provide that because of HIPAA, regardless. And basically we're trying to get them to understand that you can raise HIPAA, but the court, within the statute, the court can make the determination. I mean, HIPAA is not the end-all and be-all. You know, the court can get around that, you know, for whatever reasons the court determines, you know, the information is needed. And the same thing is true with the parent. If the parent doesn't want to release, like generally it comes to mental health information, all that happens is that they can assert HIPAA, but the judge can still hear arguments and get around it.
And I'm very glad you made that point, because that's one of the things that when we've talked about this before, the important thing, I think, what happens is people don't understand HIPAA, and if a decision maker doesn't understand anything about HIPAA, they may think just after hearing it that, oh, I can't do anything because someone has said HIPAA. And so it's important that HIPAA is not a bar to the release of information itself. I mean, and the judge is not going to make a decision based on HIPAA and say, I can't release this information because of HIPAA. The judge is going to make a determination based on the legal issues before it, which would be in a, I don't know, a child custody proceeding, whatever type of proceeding it is. We just want to get the word out to the courts that they can, you know, it's up to them what decision they make, and that HIPAA is not necessarily a roadblock. And I think this is the case, it can be the case in the juvenile courts, it can be the case in the state and superior courts, that whoever doesn't want to release records or information says, ooh, HIPAA, or ooh, FERPA, and it kind of shuts down the conversation, when what it should do is have a decision made, and that decision protects the party who's releasing it. And if they don't get it, then that's the appropriate decision of the judge, but it's up to the judge for other reasons. Do you agree with that assessment?
I do, and I think the idea is, oh, it's a federal law, I'm a juvenile court, what can I do about this federal law? Not understanding that you have the ability to take care of this. And when you think about it from a provider perspective or from a covered entity perspective, they have the medical records, they want theoretically to give them to you, they just need the permission to do that. Even if later the court order is found to be improper for some reason, and the court didn't have the ability to order, or for somehow improperly order the production of those records, the provider is protected from liability at that point because they issued them pursuant to a court order. So as long as the provider is able to follow whatever the court is saying, that's where the protection exists for the provider. So that's exactly right. The judge has that power to deal with that situation directly.
And I think if you're in a FERPA situation, the same thing is really true of, we've talked about, of what is a valid subpoena. I think that all that's required is that you make a reasonable review of the subpoena to make sure that it appears to be a valid subpoena. It's not quite the same as, have you properly served your lawsuit? Yes, sir.
Oh, we had a question. Oh, I see.
Representing defects, valid subpoena means it absolutely must be signed by a judge.
And you're probably correct. But what I'm saying is, under FERPA, if a school gets a request for records, if for some reason they've got case law or they've got some precedent or some reasonable legal reason that they believe a subpoena is proper, they're going to be protected. As long as they're making the decision for a reasonable based on a reasonable legal basis. But you know, there's not I don't think you're going to be held in violation necessarily if someone's lawyer consults with them and says, yes, I think that's a valid subpoena, and later it's determined that it's not a valid subpoena. You know, it's different. There's no financial or criminal liability under FERPA. It's not the same as HIPAA. Right.
Minimal standard steps, and then it's possibly disclosed. So there's a number of steps that we have to go through.
Right.
And again, I think that comes back to the issue of HIPAA is not an affirmative duty on a provider to release records. It's just kind of the roadblock before you get there. So the provider can choose. You have to, you know, file, I want to get this form in quadruplicate and I want to have it filled out 3 ways in purple pen. And until you have that, I'm not going to release the records to you. They get to make that determination as long as they're not violating state law and refusing to release records.
Or violating a court order or
anything else. But if, for example, a provider says, well, I'm only going to accept as valid subpoenas that are signed by a judge, well, then basically they're just saying I'm going to fall back on the court order kind of scenario as it relates to subpoenas. And that's, the provider is able to do that.
The question that I have is in regard to stepping out of the juvenile court arena with the HIPAA, going into superior court, or not yet to superior court, where you have a criminal action where people are trying to get the defects records. For instance, law enforcement and also the DA's office, there's not a court order out there, and you've got HIPAA information that is included within the defects record, the educational records, the medical records, not only of the child, but the parents that may be in there. You know, you've got the CCFA with Uncle John making the disclosure. What is the next step for the department to do when you've got a DA office saying, hey, I want a copy of your records? Because per the statute, you're supposed to be cooperating,
Right.
and, you know, and that's what we've been, you know, told to do. We're supposed to cooperate with the DA's office, law enforcement, in regard to these allegations of abuse in one way, shape, or form, because now it's in a criminal matter in regard to it. What is a way for DFACS to also protect itself from those type of requests?
And I think the best way is really to fall back, you know, and say, hey, we're a covered entity. We've got to be very careful about how we release this. I need a subpoena from you. Now I need a court order from you. I need one of these ways, or you've notified every individual. You've got to make sure you've checked off all these boxes as far as releasing that information. And that's not a matter of trying to stand in the way of what the DA is doing, but it's just a matter of making sure DFACS meets its legal obligations before it releases protected health information, because otherwise it could be subject to very serious liability.
And if they're seeking education records, I mean, they're under FERPA, and their records can be released to under certain circumstances to certain investigators, and a lot of times that will be subject to a subpoena that comes in from, you know, the FBI, for example, or from a DA. Those records can be released pursuant to that. The issue there is going to be, do they have to give notice to the student or the child's parents of the fact that those records have been subpoenaed? And generally, they're going to have to give that notice, unless the subpoena, in a FERPA situation, unless the subpoena says on its face, it would be damaging to the investigation if the parent was notified. So please do not send notice. And then the institution won't send notice to the parent that the records have been requested.
Other questions? Yes.
I had a case where I represented the birth mother of a child who had been taken into custody by DFACS. It was an infant. Had the birth mother sign a medical release, a HIPAA-compliant medical release, asking DFACS to give me all the records. And DFACS just stonewalled me. They wouldn't respond. They wouldn't do anything. But I would hope that DFACS would understand that, number one, I think from what you've said, I had the proper authority to secure the records that DFACS had. I wasn't in the juvenile court proceeding because I wasn't a party to the deprivation action and everything else, and I don't know that there's somebody here from DFACS who would talk about DFACS having some uniform policy on how it's supposed to play ball and be fair, because it was sort of like the SAG just wanted my cooperation with anything he needed from the mother, but he wasn't about to give me any cooperation. I thought I had done everything right, but and I'm hearing here that I had a valid surrender.
Well, and it comes back to the point that HIPAA doesn't require anyone to release the records, the covered entity. It doesn't require it. And so I think your options...
So the owner, the mother, the owner of the record had no right to
yes,
ask...
Yes, she had the right to the records of her child.
Okay.
And
DFACS had them.
And DFACS had them. But
as I was her agent, I couldn't get them.
Well, and what the way I would interpret that is, I would say that a demand needs to be made under the particular statute in Georgia that says my medical records are my records, and I have the right to a copy of my medical records at any time. Okay. And so a request, you know, a letter request stating that and saying, I'm entitled to the records and I'm requesting the records, and if I don't get those records, you know, I'll an action in court or whatever remedy there is under the statutory scheme for getting medical records and having your right to medical records. But HIPAA is not going to demand that someone produce records. You're going to have to look at the appropriate state law that requires them to produce the records.
Okay, so HIPAA punishes you for violating the inappropriately disclosing,
right,
but won't give you any teeth to get disclosure. You go to state law for that.
It's not going to punish a covered health entity that doesn't provide records. There's going to have to be another avenue under state
Okay.
or some other law or regulation requiring the production. Under FERPA, that's a separate thing, but of course that wasn't applicable there. I mean, parents have the right under FERPA to get their child's records and a requirement. Under FERPA, the entity can lose federal funding. Not going to happen.
I just wanted to dovetail back to the question that this lady asked over here pertaining to disclosure of records in connection with criminal matters. And I understand what DFAC's responsibility is in terms of their being a covered entity. But suppose as a child's attorney, say it's a physical abuse case, and of course we get their medical records and all that information too. We have that in our files, you know, and sometimes we get calls from, as DFACS does, the district attorney's office, you know, asking to access those, you know, that information. Are we, I mean, we're not considered to be covered entities, is that correct?
That's correct. As long as you're not providing the services, you're not actually the one paying for the services, providing the services.
So if we get a request from a district attorney, you know, to access our client's medical records, it's okay for us to share that information?
Right. As long as you have them in your possession, you're not a covered entity. There's no penalty for disclosure. Now, there may be a penalty for disclosure under state law or if there's some other confidentiality rules that relate to those records, but under HIPAA, there's no penalty if you're not a covered entity. So that'd be correct.
You're an attorney for the parent?
For the child.
For the child, I'm
Yes.
sorry, for the child.
Yes.
Okay.
I guess I had a comment or a question about the gentleman that was asking earlier about what was in the files. You're also talking about third-party information, which if it's medical information given to a third party, not something created as something that DFACS has purchased or contracted for, even if you sign the FERPA, that right doesn't belong to DFACS to disclose. Any third-party information is supposed to be obtained from the provider that it goes in. At least that's always been the policy, as I've known it, is even if DFACS holds something, if they are not the owner of that record, they can't disclose it to you.
Is that correct under HIPAA, that it's going to be under FERPA, there are certain restrictions on, but when a release of records is made under FERPA, it's supposed to say whether it can be disclosed to any third party.
Right, but
following that.
But I think the DFACS policy is if they don't own the record, they cannot disclose it or they will not disclose it. So if you're asking for records, at least in juvenile court from DFACS, you have to ask the right entity.
I'm not sure that, I don't know what the answer to that is. I really don't.
And again, as a covered entity, DFACS has the right to decide what records they're going to release or what records they won't, but I don't think they can throw up a HIPAA flag for that reason, but I think they have still the decision as the covered entity to choose what they're going to release or to say you have to go to the provider.
Whoever wants those records
Yeah.
would come to you, the judge, and
Right.
Seek an order.
In this case, DFACS was the only one who knew who the provider was. They took the child to the provider, so.
The one thing that I've also come across with the juvenile court that I deal with is that sometimes within the HIPAA information that a parent's trying to get, for instance, the child's information, is sometimes some of that information can be detrimental to the child. So sometimes we have to ask for that information to be redacted before the court will allow somebody to get their hands on it. Let's say that the child has made a disclosure against the parent, and if the parent wind up getting a copy of it, the retribution of the child is at stake, so there could be some imminent harm if the child is returned back to the parent. So a lot of times I've asked, the opportunity to redact the record just to protect that information, even though you may say that the parent has the right to get the information. It does, to me, have an element of some danger there just to release it.
I think there are some provisions under state law in Georgia that have to do with, I'm not sure whether it's psychological or psychiatric records or whether it's drug treatment records, some provision in there, and I'm sorry I can't identify it, but if the psychologist or psychiatrist doesn't have to produce those records, if that provider believes that it would be harmful to the individual to have copies of those records. And yours
From having him order The record I've got is to be redacted
Right.
on that child.
Which is a perfectly, the judge has the ability to fashion the remedy, which is that's perfectly appropriate
Which
as
is the
well.
advantage
So-
of a court order always, as it can be fashioned the way the parties need it to be. Yes, sir.
Question as to the mechanism.
Can you repeat that for the microphone?
Sure. Just a question, excuse me, as a mechanism of a court order, different institutions require that you name that specific institution. But if you're getting medical records, let's say, on regards to the child, you may get them for 4 or 5 institutions. You're not going, sometimes we get a general court order for medical records. Does HIPAA, is there anything in HIPAA that specifies that we have to name that specific institution? And is that general court order, does that apply to all the institutions that we'd have to visit or request those records from?
And the short answer, I guess, would be no, it doesn't necessarily have to name every provider, but if the provider doesn't feel like it's enough protection for them to do the release, then they could require you to get one that names them specifically, because their duty under HIPAA is minimum disclosure. So they have to disclose as little as possible. So if the court order is written enough to say that every single provider, which, you know, it lists out the types of provider. I mean, if you try to get it as narrow as you can without necessarily knowing the specific providers, if the provider feels like that's enough protection for them, then they can go ahead and release the information. But it may be up to the provider to say, hey, we want to get one that actually names us and names the exact types of records we're trying to get, because we're trying to meet our duty to disclose the minimum possible. So I think that's going to almost kick it back over to the provider. It's cleanest if we can list out each provider and the specific types of records you're going to get. But it's not necessarily required depending on what the provider looks at.
Yeah, you just may get some pushback from the provider if it doesn't include the name of that provider.
Other questions?
Silent.
Oh.
Okay, I don't know if I'm sort of missing it or not, but as a CASA who is a guardian ad litem, right? And we have and I don't know if you would call it a standing order, but an order that is consistent, that says records all related to the child. Mm-hmm. And then it has hospital, and it kind of names those kind of generalizations, right? So what our problem is the same as what she was talking about earlier about if Uncle John discloses something to CCF, and so they're saying you can't have the CCFA. So what is our recourse on that? I mean, are we, because we have an order, it says those things, relates to the child, which it would relate to the child. So where's the problem and the disconnect, and how do we discuss that with somebody, and who do we talk to?
And the key is you have to get an order that's broader than just the child. So the order has to cover Uncle John as well, basically. So it can't just say any records that relate to the child, because arguably Uncle John's mental condition or physical condition may have an impact on the child, but has nothing to do specifically with the child's health information. So
would it say relate? So then it would say any records. What would the language be?
And I think the language would have to name as many people as you know that have protected health information. It's going to need to say the court's going to have to order the disclosure of the particular document. So, for example, of the CCFA for that child, regardless of any protected health information, whatever protections are listed in there for that protected health information. But it's going to need to name specifically what's being disclosed and how much of it is being disclosed.
Okay, so the specific document that you're looking at, so CCFA or the substance abuse assessment on the parent, so that kind of stuff. But when we do a standing or an order that's always continuous, can it be that broad to say CCFA, or does it have to each time have to be real specific to the individuality of the case?
I mean, my thought is that you can't do one that's that broad for everything all the time.
Right.
You'd have to go basically through the subpoena rules. You could have a standing order and then have a notification and then relate to the qualified protective order and try to go that route as far as obtaining that information, if DFACS is willing to give it, basically. That would remove your HIPAA roadblock, but it may not remove everything else.
Okay.
All right.
Yes.
So we have to come back.
Going forward on one of these cases, we don't know who's going to be in the CCFA. We are not going to know who's going to be in a home evaluation normally while we're in court, but they have to get a whole bunch of releases signed. So would it be sufficient to say in the orders when you're talking about releases of pertinent health care information to say any and all protected healthcare information by any relative or person that is included in the CCFA and have that signed as a release when they go out to conduct the home evaluations in the CCFAs, because otherwise, you know, we're going to have to come back each time somebody's name comes up in the order if we don't find a broader way to handle that.
Well, it's going to depend on the providers. That's the difficulty is because if you're seeking a third party's records, that third party's not going to know anything about it.
Third-party providers that are being paid for by the department in order to facilitate these things going along at, what is it, 30 days to get your reports done? So they have a 30-day turnaround time from the time they're ordered in order to complete these things. So you would think for providers who are working within the system that they would understand why that information was necessary as opposed to somebody who, you know, doesn't have a contractual basis with somebody else. So.
In our circuit, we have, the judge has a standing order, and it covers the CCFA. So we basically have to turn that in to our SAG. So if it's helpful, I can share the judge's order with you.
That would be great.
And that again gets us back to, you know, that eliminates your HIPAA problem, basically. So if it's a matter of the entity coming in and saying we can't release it because of HIPAA, you resolve that issue kind of as we've discussed here, but then there may be other issues with the provider saying we're not going to release it because we don't release third-party information, things like that. So remove one roadblock, may still have others, but at least the major one is hopefully out of the way.
Child is in de facto custody, so as the custodian, the information regarding that child, we determine what happens to it according to HIPAA. We request something like a psychosexual evaluation on that child. And the child's also, let's add to the hypothetical, the child's also on probation for some sexual acting out behaviors. So we do a psychosexual as a part of provision of services. During the course of going through the clinical interview, the child discloses additional perpetrations on other victims. Could you address what DFACS does with that, knowing that the assistant district attorney wants it for use in prosecution, knowing that the court wants it for use in disposition on the probation, knowing that the probation officer wants it so they can violate the probation, et cetera, et cetera, et cetera.
You take it, Brian.
Wouldn't that be under may disclose?
When the child turns 18?
That's right. And I'm sorry because I don't practice anything in the realm of criminal law, so I don't know constitutionally if there are self-incrimination, what the self-incrimination protections are in that context. So I'm not sure that I can answer that in a HIPAA context at all. I'm sorry, but
under HIPAA, wouldn't it be a may disclose because it's going to protect another child? Just like if we know a child has sexualized behaviors, we need to tell the school because we need to protect the other children, not necessarily that child. So wouldn't it be covered under that?
I guess the exception for abuse, if there's evidence of abuse against other people, I guess that would be evidence that could be disclosed. HIPAA wouldn't stand in the way of that because it's an abuse record. That's exactly right. And protected health information related to abuse of somebody else.
And related to that, and someone brought this up, alluded to this when defects decides where the child is placed. I mean, and in order for the child to be provided with the proper care and supervision within the foster home, the foster parent needs to have certain kinds of information pertaining to the child. You know, I mean, how does HIPAA come into play in terms of defects revealing information to the foster parents? How does that come into play?
I know DFACS has a very involved training manual and policies related to HIPAA disclosure. Since the foster family is working under the auspices of DFACS, I don't think there'd be any limitation. They're basically all one covered entity. But I believe that's the right answer, but I know DFACS has situations that deal policies that deal directly with that issue.
And the policy says,
Addresses exactly what foster parents are supposed to be told if you go.
Okay.
can you repeat that?
Yeah, if you go on to the Otis part of the state website that has the policies, it will list those out, and it specifically under medical needs states what DFACS is supposed to be telling the foster parents and on what frequent basis.
Did we exhaust all of your questions? Our presenters were afraid they couldn't fill the time, but I think that they've not. Have you had a chance to go through the entirety of your presentation?
Yes, I'm sorry. This
Yes.
is the end.
Yes, we did.
Sorry.
I wanted to make sure because I know we got caught up in any final questions. We have a few minutes left, so there's a final burning question. Now is your chance to ask our privacy law experts. Okay, with that, then please join me in thanking them for, I'm sure, all of the learning that we walk away from.